The local warrant before Donald Webb wasn't cleared, as he disregarded everything her lawyer said. My mom's statute of limitations finished when we were in hiding, so she has no legal recourse. I called up Donald Webb to ask what would happen if Mom handed herself in. He accused me of harassing his secretary and hung up the telephone. I had been on the phone with her the day before, but the person witnessing the call felt that I was the harassed party. His secretary refused to call me by my legal name, despite my corrections. She merely kept repeating that she couldn't help me. She told me I needed psychological help because I told her that I'd been sexually abused. I grant this statement could be interpreted two different ways, yet rather than correct my possible misinterpretation, she compounded the problem. When I told her that it's exactly this kind of court disorder that makes me want to kill myself or my father, she responded by telling me that I needed psychological help because I'd like to kill myself or my father. The conversation went on and on like this. I still can't figure out how I harassed her, though. If I said anything insulting, I have no idea because I have Asperger's syndrome and am socially retarded. If I did, then I'm sorry. But in all fairness, she should recognize that what she said seemed very cruel to me. I don't like to be called crazy for reporting sexual abuse, or the idea of being categorized as a sick person simply because I was victimized. So, can Ohio's juvenile court get any more disorganized? Yes, they can. I recently got my hands on a legal document from juvenile court naming me as the defendant for not paying my own child support. Perhaps juvenile court is now advocating for child labor. So now I'm asking Sharon Evans from CPS and Deborah Rothstein from Legal Aid to please step forward and help me see if juvenile court might be missing something mentally or might be in any way dangerous to the well-being of William Bennett Bailey. When I was almost 18 years old, I filed a lawsuit against Bill and against Dr. Roger Fisher, Dr. Sam Robertson, Deborah Rothstein from Legal Aid, and Karen Christian from CHMC Children's Hospital. I couldn't touch CPS because they have total court immunity. There were many reasons for filing lawsuits. One of them was to possibly get some money so I could attend the university. Many people have criticized my decision to file because they thought it would ruin my ability to go on with my life. But I'm already stuck because of the legal, financial, and educational problems that resulted from what was done to us. People have often voiced the opinion that our court case went poorly because I was a child when the initial court case happened, and because children are vulnerable, courts have a hard time telling if manipulation is happening. What happened in my court cases proves that the courts are simply chaotic and unsympathetic regardless of age. Inventing my own solutions is best after all. Whatever path I choose, any court-abused child is my best friend. I've tried very hard to find lawyers for my cases, but most weren't interested. Others saw my plight and took advantage of me financially. However, like usual, the courts got first prize for their corruption. In my case against Bill, the court falsely claimed that my friend's residence is mine, as if I were hosting her instead of her hosting me. The court decided to bring my mom into the case as a third party at Bill's request. This meant that if Bill were found guilty of sexually abusing me, Mom would be punished instead of him for supposedly causing him to commit the crime in the first place. I worry about this kind of playing with the law because someday someone's going to witness someone's handbag being stolen and they're going to be accused of causing the person to commit the theft. It worries me how far the law can be pushed. Okay. Yes, here we are. The court decided to throw out my case on the grounds of res judicata. This means that I had my chance in court as a properly represented individual, that the former court gave a full and fair hearing, and that whatever topic I'm bringing up is an old issue that the former court already resolved. Well, first of all, I was bringing up a new topic, so it could not have been res judicata, because even if they rightly claimed that sexual abuse was brought up in domestic relations during my childhood. Issues of emotional abuse, physical abuse, and mental abuse were not addressed at all in domestic relations, and my court filing against Bill had those things included in it, and that was completely ignored in favor of determining whether sexual abuse took place or not. So it could not have been res judicata just based on my filing alone. Okay. The court began their first fallacious argument, that I was a properly represented individual in court. Obviously, I wasn't a plaintiff or a defendant in domestic relations. So the court tried to get around this by claiming that I was legally represented through my mom, as our interests were supposedly identical. As proof of their claims, they falsely accused my mom of refusing Bill visits, claiming that it was obvious that we were in league together concerning the visitation issue, as neither of us wanted visitation to take place. What claptrap! Even juvenile court disagreed with their claims. Their wish to hire the lawyer, Deborah Rothstein, for me was specifically based on their claim that I'd had no representation in the previous court, domestic relations. Still, this new court foolishly claimed that I was a legal litigant from the day of my birth until the case was transferred to juvenile court. Next, the court sought to prove that sexual abuse was the legal issue before the domestic relations, and that they had a full and fair hearing that dealt with it. Their proof for these claims was based upon two things. Referee Kathy King supposedly did an investigation to see whether or not I'd been sexually abused, and in her final report she concluded that she didn't believe Bill had sexually abused me. I clearly demonstrated in the first part of my story that sexual abuse wasn't a filed issue before the court, but rather refusal of visitation. Investigating sexual abuse had nothing to do with refusal of visitation in the least, and so sexual abuse was a hindrance to the investigation of the legal filing at hand. Proving or disproving sexual abuse occurred didn't prove or disprove that my mom refused visits, nor did it prove or disprove that my mom had motive to refuse. Even if one conclusively proved or disproved sexual abuse, such facts bear no relevance to whether or not my mom believes abuse had occurred or not. Since referee Kathy King and Bill never proved that mom believed abuse had happened, they crucially failed to prove the existence of a motive. To legally link sexual abuse with refusal of visitation, the focus of the investigation would have had to be on my mom's belief about abuse, not on the abuse itself. Considering the referee claimed to be investigating the abuse rather than mom's beliefs, I'd say she was way out of order. Even if one generously assumes that abuse was being investigated by a referee for the purpose of determining if there was alienation or not, she would still be out of line. Proving or disproving abuse would never prove or disprove whether I was being alienated or not. Remember that a child could be alienated by one parent while simultaneously being abused by the other. So it was a legal fault of the referees to investigate sexual abuse claims in the first place, if that's what she thought she was doing. My sexual abuse wasn't the legal topic before the court, nor could it have truly been a legal subtopic. When the referee asked my mom whether or not she believed abuse had happened or not, she honestly stated she didn't know, and all she knew was that I was making abuse claims. What was the referee investigating, or did she know? Was she investigating a full and fair hearing based on evidence? She obviously had no idea what she was investigating. In her final report, she claimed it wasn't her role to determine whether or not I was abused, but whether or not Bill had abused me. Since Bill was the only one being accused by me, accomplishing her role properly would have been impossible. She seems to have totally forgotten that she was supposed to be investigating refusal of visitation. So in essence, she tries to separate topics that can't be separated and join topics that have nothing in common. As to giving a full and fair hearing, she obviously didn't do that. None of her final conclusions were based on the evidence presented before her. She based all of her conclusions on Bill's unproven and unverified hypotheses. Mom's lawyer proved that my mom never refused a visit. All psychological evaluations and opinions demonstrated that alienation by my mom didn't exist. One psychologist claimed that Bill had abused me, while the other one simply wasn't sure. Nobody but Bill condoned the opinion that Mom was manipulating me or that Bill didn't abuse me. Therefore, since the referee's conclusions are only based on Bill's opinion and contradict all realistic evidence, there couldn't have ever been a full and fair hearing. I presented the above arguments to the Court of Appeals in the legal format I found off the computer. They rejected it on the grounds that there was a small mistake in the forms I presented. How sad. My case against the corrupt psychologist, my former lawyer, and Karen Christian from Children's Hospital was thrown out by the federal court. Their corrupt decision was based on legal loopholes that affect a vast percentage of Americans living abroad, but few are aware of it. If anybody has legal problems in America, there are two types of courts to call on for help: the local courts and the federal courts. I didn't understand the laws when I filed my lawsuits, but lawyers kept telling me the case against Bill needed to be filed in local courts, whereas my other case needed to be filed in federal court. It turns out that for any local court to accept a case, the plaintiffs must have residency, their own address, not somebody else's, and or be domiciled for at least 6 months straight before filing a lawsuit. Otherwise, the local courts can't accept the lawsuit. So, you need to be domiciled in America for 6 months before filing a lawsuit in the local courts, and you need to have residency or residency. One or the other. You have to have fit one of these two conditions to file a lawsuit there. The federal courts, on the other hand, may only accept cases in which there is no residency, no domiciliation, and where the plaintiff has dual nationality. Well, I don't have dual nationality, so that pretty much eliminates that. The federal court threw out my case because they claimed that I was in the wrong court. I didn't have dual nationality, and the federal court falsely claimed that my friend's residency was mine. So, since I have no residency in America, haven't been domiciled in America for 6 months straight since childhood, and don't have dual nationality, there's no court I can sue in. Essentially, I have no legal rights. I believe that my statute of limitations are now over, so because the court stole my rights as a child, and I needed to get the protection they refused me, and because my mom protected me, the courts can walk over me some more, rather than correct the severe consequences which I shall be forced to deal with for the rest of my life, stemming from their initial abuse. One lawyer I hired doesn't want to believe that my time to sue is finished, but instead suggests that my statute of limitations starts ticking away once I've been domiciled in America for 6 months. Considering how many other people on the internet have talked about having the same problems as I have had, it seems unlikely that the American law is helping people. Quite the contrary, it seems the American law is violating people all the time. Just think, foreigners vacationing in America may have more legal rights than American citizens. And if President Obama or his mother had been run over by a drunk driver during their first 6 months following their return to America after living abroad, it's quite plausible they'd have no rights to challenge the drunk driver. Talk about a crazy system. Any intent without law is dangerous, but law without clarity is even more dangerous. If anything is to be done about equal parenting, or parents getting constitutional rights to reasonably parent as they say fit, CPS and court corruption must stop, and the law must find a means of properly determining if children have or have not been abused. Dr. Richard Gardner's PIS alienation version is destroying the lives of genuinely abused children, as it doesn't help protect people differentiate between abuse and alienation symptoms. I've got great ideas on court reform that I know will help stop court corruption, save abused children, and help enforce shared parenting where it's beneficial. I'm appealing to the American public to help me. I was born in a high-standard, middle-class home, but I shall almost certainly live and die in poverty for what's been done. Yet, what I mourn the most is the death of the America's soul, which can only become more manifest in future generations. Yours sincerely, Bethany Ann Farmer. That's the end of my letter. I have my court proposals, which I will read aloud. I have written them out, and I will explain it as best as I can. In order of power, I'm proposing the system be reorganized. What I'm proposing is that we have something that I call A, that oversees CPS and two separate court branches that deal with separate issues. So this would be, as I would call it, I will call it A, and I will call it Overseers to Prevent Corruption. It would be a sort of prevention of court corruption, a way of correcting mistakes that happen in the system, so that nobody has to be screwed by the system anymore. These people would have many, many rights. They would have federal funding. They would be located state to state. There would be many of them, like a jury, and they would go through cases in which corruption has been found. So, A, Overseers to Prevent Corruption would have power over CPS, would have power over a court branch that I will call Court Branch C, and they would have power over another court branch which I will call Court Branch D. They would have the right to investigate any and all cases under CPS and court branches C and D, in which it's logically reasonable to believe that corruption exists. They would have the right to promote, demote, fire, fine, change child custody, and physically remove children if corruption is verified. Court Branch D that I'm proposing be created. We have enough judges, it's just a matter of getting them organized. This would be all the way a nationwide thing, all the way across America. Court D would have abuse cases involving child abuse, and only child abuse. They would get high payment, and they would be the second most powerful court branch underneath A, which would be the Overseers Against Corruption, who covers everything. There would be no legal immunity in Court D against child abuse for judges, magistrates, referees, lawyers, psychologists, psychiatrists, and/or any other court-affiliated person. A panel of 4 to 5 judges would be randomly picked out of a hat full of a list of judges specifically trained to deal with child abuse. Ex parte hearings would be entirely forbidden. Any court-appointed official found to be participating in ex parte hearings would be subject to massive fines and/or loss of jobs, which would be imposed by A, the Officials Against Corruption. All mental health professionals involved in D cases, abuse cases, would be randomly picked out of a hat full of lists of mental health professionals specifically trained to deal with child abuse. Nobody apart from lawyers would be handpicked. All other persons in D abuse cases would be randomly pulled from court lists. Both plaintiff and defendant would both pay 50% for each mental health professional that is randomly included in the case. No court personnel in or related by extension to the court would give time favoritism or emotional favoritism. All decisions must be thoroughly backed up by sound, logical testimony and logical backed up psychological evidence. Any court personnel or court-related personnel who breaks these rules would be subject to a loss of job and major fines imposed by A, the Overseers Against Corruption. Domestic violence evidence concerning children that precedes divorce would be presented as evidence and be allowed to be presented as evidence after divorce. Too many cases have children who were abused prior to divorce and because the evidence may not be presented, are abused afterwards. This does not make sense in court, that you're not allowed to present child abuse evidence just because it preceded a divorce. None of that makes sense. Likewise, the idea of having a panel of 4 to 5 judges, I will explain, and having anonymity, and having these people specially trained in child abuse would be to help it be more like a jury setting. Under jury settings, child abuse is a lot less condoned. There's a lot less chance of bribery. There's a lot less chance of corruption. A lot less chance of hired guns being paid off by people to present whatever opinions they have in court. It would be hard for somebody to pay off 4 or 5 judges plus 3 mental health professionals, all anonymously picked out of a hat. So it would be harder for abusers to get away with abusing the system in order to abuse their children. That's the logic behind that. As to ex parte hearings, I've heard of so many cases where people have their kids removed unfairly because one person gets in and they say all sorts of things about the other person who's not there, who can't defend themselves. It's not justice. It's just a way of getting your side heard without the other person. It's a bias. These hearings are wrong and they should be eliminated. No child should be endangered ever again. So, that's something that would need to happen. Furthermore, in D cases, all cases transferred to Court D, dealing with abuse, with a note of emergency attached to it, would be given top priority, so that children with more severe abuse cases would be heard quicker. Not to say that the others are not important, but we do need priority if someone's going to die. Court D, against abuse, shall have the duty to take into account the financial status of the individuals before them with regards to child support. More rigid consequences shall go into place to enforce child support laws against those who maliciously refuse to pay. On the other hand, those who honestly can't pay shall be given great leniency. Judges, magistrates, and referees who improperly fail to follow the guidelines concerning child support shall be subject to penalties from A, the Overseers Against Corruption. The idea behind this is we won't have any more cases where these crazy parents waltz off with millions in their pocket, not supporting their kids, which is often what happens. On the other hand, more leniency needs to be granted to people who can't afford to pay, to feed themselves, to clothe themselves, and are being asked to pay for their children as well. It's just not practical to put people like that in prison for no reason at all, just because they can't pay. The system is enforcing on people who can't pay and not on those who should pay. That needs to stop. Okay, any persons found to be hiding or refusing to hand over tapes or files to the litigants or to Court A, Overseers Against Corruption, shall be subject to job loss and big fines. The idea behind this is that this way, in cases like in Ohio, for instance, where tapes disappear and you're not allowed to go to the appeals court because of this, everything's supposed to be taped. And when files and tapes disappear in Ohio, you're not allowed to appeal without the material to appeal with. So a lot of people get screwed in the Ohio court system because of this. This would help to eliminate that these people would be punished by the Overseers Against Corruption, and if they tried to hide tapes and stuff, they would be held accountable for their actions. Okay, abuse cases on children take priority over all else. Therefore, all evidence, apart from child abuse, and all proceedings from the other court branch, C, are to be null and void until the D panel, against abuse, of judges renders a no abuse verdict. If an abuse verdict is rendered, then proceedings and evidence from Court Branch C, the other one, shall remain null and void. If the D panel, against abuse, renders a no abuse verdict, then the case in question is to be returned to Court C, and prior evidence and proceedings shall no longer be considered null and void. The idea behind this is if there are 2 different court branches, one would take precedence over the other, because child abuse often involves death of children and problems like that. Alienation, it is a severe problem, and there are problems with domestic violence between parents, but when it doesn't involve the children, it's not quite the same story. Likewise with alienation, if the child's killed with an axe jammed through their head, it's not like there's a child left to alienate. So let's protect the child's life and their physical interests and so on and so forth as first, so that we might be able to protect them psychologically as well. Okay, and I think we all know that being around an abuser is not beneficial. So this court here, Court D against abuse, would have the duty to make sure that children are separated from genuine abusers. There would be no more confusion between this alienation versus abuse problem. That's the reason for having two court branches, so they can both deal with different issues and not individual judges anymore with no psychological knowledge. No more hired guns, no more paid-off judges, no more individual judges deciding cases, no more confusion between alienation and abuse. Objective thinking, fair trials, no more hired guns, people protected, situation dealt with. Most judges, I don't believe, know what their objective is anymore, especially when they end up with a case where there's alienation versus abuse. Okay, to continue. It is the objective and duty of Court D against child abuse to stop child abuse. Therefore, children will not live with or visit a convicted child abuser. Any person in D court guilty of violating this rule shall get the worst degree and version of punishment from A, overseers against corruption. Any court representative hired to defend a child's rights may be fired and replaced by the child if the child feels that his or her rights aren't being properly represented or defended by the said representative. I had someone named Deborah Rothstein hired for me, and I don't have a right to fire her, no matter what she says or does. This has happened to many children where these court-appointed people step in, do exactly opposite of what the children want, and the children don't have any right to change the person, get rid of the person, bring in somebody new. That has to stop. It ruins children's lives. Okay, Court D would be strictly forbidden to accept CPS reports, opinions, and or recommendations in court. CPS would have no part or place in D proceedings. I think that's very important because sometimes CPS really oversteps their bounds, as can be seen in my case, and they try to take kids away, and there's no reason, and they don't know what's going on in the case, and they just come in riding on their supposedly shining horse, and they damn everybody. That's not constructive. And excuse me for saying the word damn for anyone who's sensitive. The only involvement of CPS, which they would have with D court, would come at the end of cases in which an abuse verdict is rendered. CPS's only involvement in D cases would be for the sole purpose of removing children from abusive environments to safe environments. All D panel judges who have rendered an abuse verdict in a case and are preparing to remove a child or children from an abusive to a non-abusive home must each first write a letter to CPS explaining their individual reasons for wishing to remove the child or children from one atmosphere, along with their individual reasons to believe the children would be better off in the new environment. The reason for this is that judges don't have to give reasons for why they're taking children away currently. They take them away on flimsy grounds and nobody can catch them. There's no legal liability. Writing out papers would help clarify why they're taking children away, what their reasons are, and stop these silly court cases from going flying in all directions that overburden the system and waste everyone's time. Okay. Finally, any court employee or court-affiliated person who recommends foster care for a child or children who have a loving, non-abusive, and reasonably capable parent to live with shall receive the worst penalties possible from A. The foster